the arrest form.
Your Honor, for the record, I'm seeing that the defendant has a prior carrying concealed weapon charge from 2014.
I'm sorry, is this Mr. Walker?
Sir, I'm not seeing that.
One moment.
Mr. Topin, Larico Walker is a defendant before us. I'm seeing one misdemeanor prior locally for cannabis possession.
Juvenile record, Your Honor. He's only 18.
So you're referring to a prior record in juvenile court?
That's correct, Your Honor.
And what is in that record? Because I don't have that.
It's a charge of carrying concealed weapon, concealed firearm. It's also with the same charge.
Oh, okay.
Yeah, evidence, destroying, tampering. I'm still reviewing.
He might be on probation.
All right, wait, I'm confused. Are you reiterating the charges here from this case, F1523973?
No, this is a arrest from 2014, Your Honor.
Okay, so tell me again. These are open, or is this...
I'm reviewing that right now.
I don't see anything on this prior. 2014, he would have been a juvie, but...
Okay.
Well, it appears to be a juvenile record, Your Honor.
I'm finding probable cause on this case before the court today.
And it looks like the 2014 charge was adjudication withheld disposition April 2015.
And he was sent on a 1-year probation, Your Honor, so he's currently on probation for that.
On juvenile, right?
All right.
Would Your Honor entertain
defense
arguments at this point for Mr. Walker?
I'm finding PC. What else would you like to request?
On behalf of Mr. Walker, Your Honor, I actually have some PC arguments. As to the grand theft of the firearm charge, there's no indication here of when the actual firearm was stolen. It simply states that it was reported stolen, but we have no idea if it was reported stolen in the beginning of the year. So I would say that there's no PC because there's no connection that Mr. Walker was the gentleman who in fact stole the firearm, Judge. As to the carrying a concealed firearm,
Wait a minute. Your argument is that he didn't steal it, but the charge is possession of a stolen firearm.
Oh, because I see here on the arrest form it says grand theft. Also, I believe it's count 4, grand theft of a firearm.
Okay. Let's start with the first count, which is possession of a firearm.
In that case, Judge, I would argue...
Which is a second-degree felony, the most serious charge.
Yes, Judge.
Okay.
So as to count 1, Judge, I would argue that in the 4 corners of the arrest form, there's no indication here, there's no mention by the officer that Mr. Walker is a convicted felon. As to count number 2, possession of a firearm at I guess it's a school event, I would indicate that there's no indication here in the arrest form that this is a school event. I understand that it says a football game, but it also doesn't tell me if this is like a division football game, if it's an actual like school, is it a community football game, is it actually a school entitled event? As to count 3, for carrying a concealed firearm, I'm not, based on the 4 corners of the arrest form, Judge, it says here that prior to entering the football game that himself and the 4 defendants were stopped, but the arrest form also indicates that the firearm is located under the front passenger seat. It doesn't indicate that Mr. Walker was carrying the firearm on him when he walked into this football game, this event, or when he attempted it. And again, as to count 4, there's just no connection. There's no connection, no nexus between him and the theft of the actual firearm, Judge. We don't know. In fact, the case number starts with a 12. It might be a gun that was stolen from 2012, Judge. So we would submit that there's no connection, that Mr. Walker has any connection with the theft of the firearm.
Okay. Thank you for those arguments. State.
Your Honor,
for count 4, Your Honor, there is a police case number under which the firearm was reported stolen. The defendant was in possession of the firearm. There is a presumption there that is sufficient to establish probable cause. For count 3, Your Honor, the concealed carrying, he placed a Glock pistol under the front passenger seat. That is sufficient for concealed carrying. For the second count is possession.
The school event.
Your Honor, it's a football stadium. There's an address for the football stadium. It's at a high school. The defendant is 18. He's with co-defendants, and that is established that it was more likely than not, a school event at a high school football stadium. And as far as the first count goes, Your Honor, we just read to Your Honor the record from his brief, which proves that he's on 1-year probation, felony probation in juvenile court for gun charges.
And Judge, if I may, at this point, I understand that the state attorneys have read to you his record, but again, Your Honor is supposed to stay within the 4 corners of the arrest form. In the 4 corners of the arrest form here, the officer doesn't indicate that he's convicted. Furthermore, it's unclear to me as the conditions of his probation. Unfortunately, I'm looking at a limited prior sheet. It just says out on probation. It doesn't tell me what a withhold or something that would be turned into a withhold, making him not convicted if he were to successfully complete the probation.
Okay, I've heard enough argument on the case, and I'm not going to find PC on count 1, but I will find PC on count 2, 3, and 4. At this point, based on what I've read here, I'm going to be denying bail because I don't believe there's any condition of pretrial release that can reasonably protect the community from this defendant or assure the defendant at trial or assure the integrity of the judicial process. I just cannot grant any kind of pretrial release. Is there anything further on this case?
If Your Honor, a total of 15, Judge, then?
15.
1,000?
No, I'm ordering no bond on these 3.
Oh, I'm sorry, Judge. I was confused. I thought that you were sticking to standard.
All right, so count 1, I'm actually RORing on. I'm finding no probable cause. Count 2, count 3, count 4, I am finding probable cause and ordering him held no bond.
Judge, then, to at least supplement the record, our argument at this point, Your Honor, is that Mr. Walker is 18 years old. His contact with the criminal justice system is very limited. He is entitled to a bond, Judge, or the presumption is that he's entitled to a non-monetary bond. At this point, elevating the bond to no bond is no bond, Your Honor. For Mr. Walker, whose contact is very limited, we would be asking for the standard bond.
Okay. Thank you for the argument.
An ankle bracelet if Your Honor is concerned about the safety of the public.
Any additional argument, State?
Staying on our initial arguments.
All right. Next case, Eddie Brown.